By the impugned order dated 27/1/2021, the learned appellate court additional district judge judicial, Jhansi has rejected the application under section 5 of the Limitation Act filed along with the memo of appeal and has accordingly found that the appeal was not maintainable staff. The appeal was filed under section 67 5 of the Uttar Pradesh Revenue Code, 2006 staff para. Sri Vinod Kumar, learned counsel for the petitioner, contends that the appeal of the petitioner has been rejected on grounds of delay staff. It is submitted that the delay was due to bona fide reasons staff. The learned appellate authority took a highly technical view of the matter staff. It is further contended that the impugned order dated 27/1/2021 shows non-application of mind staff para. Per contra, learned standing counsel for the state respondents submits that the delay in filing the appeal was not liable to be condoned and the learned appellate authority rightly rejected the appeal staff para. Heard learned counsels for the parties staff para. The facts relevant from the adjudication of the controversy can be prized out from the impugned order staff para. The complete record is thus before this court and no useful purpose will be served by exchange of pleadings and keeping this writ petition pending staff para. With consent of learned counsels for the parties, this writ petition is being decided finally staff para. The petitioner has meticulously explained the cause of delay in the delay condonation application staff. It has also been asserted that substantive rights of the petitioner are engaged in this controversy staff. The aforesaid facts have not been adverted to in the impugned order passed by the learned appellate court staff. The courts have consistently set their face against a pedantic approach in matters pertaining to condonation of delay, and insist on a justice-oriented approach staff para. It would be apposite to predicate the narrative with good authority in point staff. The purpose of laws of limitation is to ensure that the parties remain vigilant to their causes and institute their claims in good time staff. The mandate of laws of limitation is not to shut the doors of justice to the parties or decline adjudication on merits staff. On the contrary, it should be the constant endeavor of the courts and authorities to adjudicate issues on merits and dispense justice on a substantive basis staff para. There is good authority to hold that the courts and authorities should adopt a liberal, pragmatic and a justice-oriented approach matters of condonation of delay staff. Equally, a pedantic view should be avoided and servitude to procedure in such matters should be eschewed staff para. In Collector, Land Acquisition versus Miss Kati G and others, 1987 13 ALR 306 SC, the Supreme Court took a liberal view of the phrase court sufficient cause D court and held as follows: para court. The legislature has conferred the power to condone delay by enacting section 5 of the Limitation Act of 1963 in order to enable the courts to do substantial justice to parties by disposing of matters on court merits D court staff. The expression sufficient cause court employed by the legislature is adequately elastic to enable the courts to apply the law in a meaningful manner which subserves the ends of justice, that being the life purpose of the existence of the institution of courts staff.